Hello and welcome to 4IP Council's webinar, Downsides of Using Inadequate Open Source Software Processes and Licenses Within Standards Development. My name is Axel Frazzini and I'm the Managing Director of 4IP Council, and I will be your host today. As you may know, 4IP Council is a not-for-profit organization, and we are developing high-quality academic research and insight on topics related to intellectual property and innovation. This webinar, one of many, we will run over the course of 2021. We also conduct education activities, including the creation of resources to encourage innovative SMEs to grow their businesses using IP. Visit our website for a range of free materials. The slides and a recording for this webinar will be made available on our website tomorrow. If you have questions for the speakers, please post them in the Q&A area on your screen, not the chat, but the Q&A area. But without further delay, allow me to introduce today's great speakers. We have on the left-hand side, Michele Herman. Michele is the CEO of an early-stage health tech startup and the founder of JusTech Law, where she provides services focusing exclusively on legal and business issues affecting technology development and commercialization. Previously, Michele worked for several companies, including Microsoft, where she last served as Associate General Counsel in Microsoft IP and Licensing Group. Michele has been an adjunct professor at Seattle University School of Law and has guest lectured on numerous occasions at University of Washington School of Law on both standards and open source software. Michele has also held several leadership roles on licensing standards and open source committees in organizations such as the ABS section of Science and Technology Law, EPLA, and IPO. Michele received a BS in Electrical Engineering from Rutgers University, a JD from Rutgers University School of Law, and is registered to practice before the US Patent and Trademark Office. On the right-hand side, you have Dr. Justus Baron. Justus is a senior research associate at the Center on Law, Business and Economics at Northwestern University Pritzker School of Law. His area of expertise is the empirical economic analysis of technological innovation and markets for technologies. His main research interests are technology, standards, patents, and licensing schemes. Dr. Baron holds a PhD in economics from Mines Paris Tech and a master's degree in economic governance from Sciences Po Paris. His work has been published or is under revision in leading academic journals. He is a member of the European Commission's expert group on standards essential patents and has authored several studies on the European Commission's Joint Research Center on FRAND, licensing and the governance of standards organizations. Without further ado, Justus, the floor is yours.
Yeah, thank you so much, Axel, for the kind introduction. And let me start by thanking 4IP Council and the organizers of today's webinar for having us for this great webinar. And let me start with a preview of our presentation or a summary of the research that we have been working on. There's a growing recognition among standards organizations, policymakers, and business practitioners that there are many significant and potential benefits of a tighter integration of open source software and standards development processes in standards organizations. Perhaps less well understood are potential downsides of doing so using open source processes and policies that are not well suited to the SDOs in which they are being implemented. So as I'm sure many of you are all aware, there's a wide variety in open source licenses and models. And accordingly, standards organizations have experimented with different licenses and different models. And some formal SDOs have used models and licenses that we will argue are not particularly well suited to their task. including licenses that require royalty-free patent licensing and that feature meritocratic decision-making processes. In order to analyze whether these licenses and processes are well suited to standards organizations, it is important to also focus on the use case, meaning the particular role for which open source software is used within the standards organizations. And in this research, we have chosen to focus on one particular use case in particular, which is the development of open source software reference implementations that are developed and in a process hosted by the SDO itself and that are then endorsed by the SDO as a truly compliant implementation of the standard. We argue that these processes have the potential to perhaps dominate the market for the implementation of the standard, but for sure to influence standardization decisions in the course of standards development. Accordingly, it is important that SDOs apply a consistent set of policies, including the principle of consensus decision-making and balanced IPR policy across their activities, including these projects for the development of reference implementations, in order to preserve the general openness and balance that they strive for. Next slide, please. So at the outset, let me point to the many important synergies between open standards and open source software. As the name already indicates, they both aim to provide for a collaborative technology development process that eventually encourages the widest possible implementation of a new technology. This being said, there are subtle differences between what openness means in these different contexts. In the context of standards, openness refers to a process under which these standards are developed. So when we speak of standards here, it's important to keep in mind that these standards in practical terms are documents that include a set of technical specifications for products that are required for products to be seamlessly interoperable. And what SDOs traditionally do is that they host a process for the development of these specifications that is open for the broadest range of possible interests to participate, and then the resulting documents are available for implementation to anyone on a voluntary basis, and also if there are intellectual property rights that are essential to the implementation of these standards, that licenses to these essential property rights are available at least on a fair, reasonable, and non-discriminatory basis. Traditionally, the SDOs themselves do not participate in developing implementations of the standards. So when we speak of implementations, these are products or services that actually conform to the specification that the SDO has developed. That includes software-based implementations. So these have long been developed in a variety of different models, including proprietary models or open source software that is fully conformant to a standard that has been developed by a formal standards organization. So when I say open source software, the open in that context refers to the characteristics of the license that governs the development, the distribution, and the use of this particular piece of software. And Michele is going to speak about that in much more detail than I will. And until recently, there has not been that tight of an integration as we have seen more recently, because the SDOs did not themselves develop implementations except for relatively narrow exceptions. And when there has been open source software implementations of technology standards, these have traditionally been developed outside and separately from the SDO by a diverse set of open source software communities. Next slide, please. So there's, in addition to the wide variety of standards, there's a wide variety of institutional settings in which standards can be developed. Most of these SDOs are private organizations, and as a general matter, standards are generally voluntary. And this means also that there is not a general specific requirement that a particular process needs to be followed in order for standards to be developed. But there is an important set of standards for which more specific procedural requirements exist. Notably, that includes formal standards development organizations. So when we speak of formal standard development organizations, we generally mean the body of the global, regional, and national standards bodies, which are often formally recognized by national governments, or in the case of the European standards organizations, the European institutions, and also standards organizations that are accredited by an accreditation body, such as ANC. In addition to these formal SDOs that are subject to specific procedural requirements that are attached to the recognition or the accreditation that they have received, some SDOs, as a practical matter, wield a very significant influence over the industry in which they operate. And as a consequence of either this formal status that an SDO has or the practical significant influence that an SDO holds over an industry, they might be subject to heightened competition law scrutiny. But this is not to say that these requirements are generally applicable to any kind of standards development. In addition to these organizations that I have just described, many hundred of other standards consortia also exist, and they might offer a wide variety of different processes that might have different characteristics and might not be subjected to the same types of requirements. Next slide, please. So in the context of Europe, when we focus just on the European standards organizations, I just wanted to highlight two pieces of regulation that give a better sense of what these specific requirements are for these formal SDOs in Europe. So one is Regulation 1025/2012, which is the regulation that describes the European standardization system. And it states that the European standardization system, which is represented by the European standards organizations and the national standards bodies of the European Union member countries, is founded on the governance principles of the Treaty on the Barriers to Trade, and that includes very general due process principles such as coherence, transparency, openness, consensus, voluntary application, independence from special interests, and efficiency. And importantly, the regulation highlights that it is important that all relevant interested parties are appropriately involved in the development of these standards. More specifically for the European standards organizations, of which there are 3, there are general guidelines which result from the direct agreement between these European standards organizations and the European institutions. And these guidelines state similar principles that institutional rules of these standards organizations should ensure that standardizers take into account the broadest possible range of views in drawing up standards and other documents. And for all type of deliverables, so this is not restricted to any kind of specific set of standards, but for all types of documents that these institutions develop, the principles of transparency, access, openness, efficiency, coherence, and voluntary work and application should be followed. So with this brief introduction into the standards development organizations, I'd like to hand over to Michele, who is also going to introduce our thoughts on open source.
Axel and to 4IP Council. Hopefully I was unmuted when I started to talk. We really appreciate this opportunity to be able to research this important and somewhat complex topic. So going back to open source implementations, it's the notion that they are important to standards development has been recently reinforced by the European Open Source Strategy Plan. I believe that was released just last October. And the plan, called Think Open, talks about encouraging European governments to use open source, contribute to open source projects, and potentially even fund them. But with respect to standards, it seems to have a recognition that open source implementations may be helpful in defining better quality standards and more interoperable ecosystems. So given that, it's really not a surprise that we're starting to see SDOs more and more start to integrate open source processes into their standards development process, whereby either open source is becomes a required part of the standard, or potentially a reference implementation that effectively defines the standard. So Axel, if you'll advance the slide. So the use of, or the development of open source, and particularly software within standards organizations, is not a new trend. For many years, SDOs have developed test materials and tools to help entities develop conformant products and services. And many of these testing materials and tools have been released as open source software. We've also seen communities spring up, open source communities spring up that will develop an open source reference implementation of an existing standard and contribute, yet another independent implementation to this ecosystem of standards conformant products and services. But what we're seeing changing now is that the SDO itself actually launches the open source project and then tightly integrates it into its standards development process. And if you'll advance the slides, Axel. And so that brings about a whole new set of considerations. And so on this slide, we have on the left-hand side, a typical sort of iterative standards development process. And on the right-hand side, we have a more typical iterative open source development process. And so models that we've seen to date commonly are develop the standard on the left side, have an open source community on the right side form, and develop an implementation. Sometimes we see the reverse. We see the open source community on the right side develop some software, and then a standards development effort take place on the left side to develop a spec around that. We've seen the communities form somewhat in parallel, but independently, where the standards development organization is developing the standard and the open source community is developing the software. The big change is now we're integrating these two processes together under the auspices of the standards development organization, and we're creating a tight feedback loop between the two processes. So for example, on the standards development side, we'll start out with a set of initial requirements. Those are provided to the open source project, which then goes to implement those requirements. And then through that process, they can determine whether these requirements are good, bad, ugly, whether they're clear, whether there's gaps, and then they can provide that feedback into the specification development process. And once that feedback comes in, the specification is refined based on that feedback. And once again, that new version of the draft standard, if you will, is implemented in the open source project, which again can provide feedback to the spec development process. So you have this continuous feedback loop of testing and feedback, and revision. At the end of the process, we have a final specification, and we're going to have a final, and if you just click for a second, Axel, we're going to have a final reference implementation, basically adopted at the same time. So this reference implementation, it's not necessarily now one of many. It is one that is actually endorsed by the SDO. It's clearly going to be considered compliant, whether it's gone through formal testing or not. And it may be the first and most important reference implementation because of its adoption at the same time or around the same time as the standard, and because of the SDO endorsement of it. And so it has the potential to become, not only because it's so much influenced the standard, but it also may become sort of a de facto implementation of the standard. And this can obviously result in some new kinds of challenges. So if you go on to the next slide, Axel. And so let's sort of flesh out the problem a little bit. So we know that SDOs have all different policies, practices, and processes, as do open source communities. So they vary from one to another. But there's some commonalities across particularly formal SDOs, those SDOs that Justus talked about, the international organizations like ISO or ITU, regional ones like ETSI, and even certain in the US, for example, fancy accredited organizations. We also know that there's open source communities like Apache, Mozilla, Linux, Eclipse, and these are sophisticated organizations. They have well-written policies and procedures. And again, they have some commonalities across them. And when we look at these commonalities on the SDO side, and we look at these commonalities on the open source community side, we see that there are some striking differences. And because of these striking differences, when we integrate those open source policies and practices into the standards development process, we realize that those certain stakeholders who may have been willing to participate in the SDO processes under the SDO, we'll call it SDO rules and frameworks, may no longer be willing to participate, in the open source portion under the open source policies and procedures. So if we lose those stakeholders, the standards development may no longer be open and balanced. Some of those things that Justus talked about that we look for in these formal standards development processes. Because those stakeholders may no longer participate, we have a risk of seeing, one set of stakeholders dominate not only the process, but clearly contribute to that implementation, which now may be much more important than others. And we also may be losing some of the due process that we associate and think of as so important to the standards development process, things like consensus voting, things like everybody who has an interest can submit comments, views, and objections that would be at least addressed somehow in advancing the standard. Those types of things could be lost because of this mismatch in these policies and procedures. So that's a problem that we wanted to take a look at more specifically. And Axel, if you'll advance the next slide. So the problem sounds, in some respects, insurmountable, but at the end of the day, it's really just making sure that we understand what the problem is and how to address it. So let's start with taking a look at SDO IPR policies. And so again, keeping in mind that the policies vary from SDO to SDO, so we're just doing sort of a generalization here for these formal organizations. But it's pretty common that contributors to the standard will grant royalty-free copyright licenses to the SDO. And when the standard is finalized, the SDO is the one who makes it available under its copyright to the public or its members or whoever it chooses to. And very rarely, almost never, almost all circumstances, SDOs do not want anybody to change that specification. So they don't grant rights through copyright to make modifications to the specification or the standard. And the reason for that is they want to promote the adoption of conformant products and services, not non-conforming ones. And the fear is if you make changes to the specification, some of those changes could really result in implementations that do not conform to the standard. And if they don't conform to the standard, you have a marketplace where products and services may not interoperate, they may not be compatible, and the standard fails. So now the patent policy will work a little bit different. For patents, there's not really an expectation that participants in the standards development are going to grant a patent license to the SDO and have the SDO sublicense those patent rights out to implementers. Instead, most of these formal SDOs have a patent policy that has a patent disclosure element and a patent licensing commitment element. For the patent disclosure portion of it, patent owners may disclose patents that they believe are likely to contain essential claims, those claims that you would necessarily infringe if you were implementing the standard, and you would declare them to the SDO. The licensing commitment would allow those patent owners who have declared those patents to agree or make an assurance that they would offer to negotiate patent licenses under those essential claims to implementers. on fair, reasonable, and non-discriminatory terms and conditions. And you'll hear us use the acronym FRAND or RAND. We may use those interchangeably, but we mean the same thing. And FRAND or RAND licenses may include royalties and other reasonable royalties and other reasonable and non-discriminatory terms and conditions. But typically, the scope of the license only needs to extend to conforming products and services, again, not to non-conforming ones. That doesn't mean somebody couldn't offer a broader license, but the SDO's primary concern is that those licenses extend to conforming implementations. So Axel, if you'll advance the slide. Okay, so now let's talk a little bit more about open source. So, what is open source software? And in the really simplest terms, open source software is just software that's licensed under a particular kind of license, an open source license. So now we have to worry about, well, what is an open source license? So there is an organization called the Open Source Initiative, OSI, that has taken on a role for itself of accrediting or certifying licenses as being open source. It does so because it developed a definition called the open source definition that has 10 criteria, and it looks to make sure the open source license meets all of these criteria. Now, not everybody agrees that this is the only definition of open source software. And in fact, many developers are starting to use other types of licenses that perhaps don't meet this OSD. OSI, however, will take the position that if your license wouldn't meet the OSD, then your software is not open source. Now, to be clear, they don't own a trademark on open source, and so it's not necessarily true that licenses that don't meet the OSD are not open source. But there is this position that's been taken, at least by OSI. Now, I want to talk about the OSD a little bit because it's very important to this understanding how these licenses interact with this FRAND commitment. And I don't want to go through all 10 criteria, but I do want to talk about 3 of them because they're important. The first one is that the license has to be royalty free. Now, OSI doesn't say that it has to be royalty free for both copyright licenses and patent licenses. And in fact, there are open source licenses that just are not clear as to whether the royalty free license extends both to copyrights and patents. But OSI generally takes the position that whether there's an express royalty free patent license in that open source license or not, patents should be licensed royalty free. At the end of the day, you could see how it would be difficult then to simultaneously offer to negotiate a FRAND license that may include reasonable royalties with somebody and at the same time be required to grant that license on a royalty-free basis. So that's one of our first conflicts. The second one is that one of the criteria of the OSD says the license has to be self-executing. And self-executing means that you don't negotiate anything, you don't sign anything, you don't even click I accept. That doesn't mean that the license doesn't have terms that you have to comply with. You do have to comply with them, but the license just downloads with the software. When I do compliance training, for example, on open source, I often print out the GPLv2, which isn't the longest open source license, but it's a pretty long one. It'll print out at around 12 pages. And the idea is, there's a lot of strings attached. If all you were saying is the software is free, it shouldn't take you 12 pages to say that. So obviously there's a number of things in that license that you do have to comply with, a number of strings that are attached. So the point that I'm making here, though, however, is that it's very difficult to negotiate a FRAND license and at the same time be required to make that license self-executing. Again, another point of tension or conflict. The final thing I want to talk about with the OSD criteria is the restriction on field of endeavor. And what that means is you have to allow anyone to take the software and make whatever modifications they want to it. And that would include modifications that would make the implementation no longer conformant with the standard. It would allow somebody to take that implementation, bring it to a competing standards organization, have that competing standard organization modify it, and then promote it as a competing standard. None of these things are in the SDO's interest, but these OSI approved licenses that meet the OSD could not restrict these kinds of undesirable activities. So can you advance the slide, Axel? Okay, so what this chart is supposed to do is help us visualize some of these tensions that we just talked about between the relationship between certain open source licenses and FRAND patent license commitments. And there is a range, a large range of open source licenses. I was just talking about those that involve conformance with the OSD, the OSI approved licenses, and those are shown in the dark blue. But the definition of open source, in our view, is much broader than that. So we're going to take a look at some other options as well. But these licenses in general can be looked at across 3 different areas of potential conflict with standards. The first one is open implementation. And what we mean by that is if the open source project that's integrated into the standards development project uses this license, do we have an issue? Can everybody still implement the standard? The second area is open participation. And again, we're talking about the open source process with this particular open source license, which I'll talk about in a moment. If that's what's used in this process, are we going to have a problem with having open participation? Will anyone be able to participate in the development process? And finally, do we have a conflict with SDO's goal of conformant implementation? Do these licenses support the notion that the SDO's primary interest is in achieving a successful standard, one that results in conformant products and services out in the marketplace? So let's take a look, starting with the OSI license, OSI approved licenses. And there's actually a wide range even within there. And so we're going to talk about them a little bit. So starting with open implementation, I mentioned before that OSI takes the position that all of these licenses, either expressly or implicitly, are going to require a royalty-free patent license. But the GNU licenses, like the GPL and the LGPL, the early versions didn't have an express royalty-free patent license, and the later ones do. But they have this other clause in them that affects implementation in particular, and it's referred to as the liberty or death clause. And basically, it's set up to ensure that the implementations, the software that's released under it, are not just where contributors grant royalty-free patent license, but the software itself is actually patent-free. And so what the liberty and death provision basically says is, if you're aware of a patent that would need to be licensed and it's not free for everyone, you either have to get that license and make sure it's free for everyone, or you can't distribute the software. And so that's a conflict with it. If somebody knows that there's a patent out there for which the patent owner has said, I'll negotiate a RAND license with reasonable royalties, they'd either have to procure that license for everybody for free downstream or not distribute at all. So that's a burden to implementation if one of those licenses were selected. There's another grouping of OSI approved licenses, several popular copyleft licenses like the EPL or the MPL, even permissive licenses like the Apache license. They have defense termination provisions in there. And how that works is, if you were to implement open source because it was either required by the standard or basically a de facto implementation of the standard, and you felt that you had to implement it, and you were a patent holder that wanted to license a patent on FRAND terms, you wouldn't be able to enforce that patent against somebody who didn't want to take that patent license from you without potentially losing your right to use that implementation and therefore develop a conforming product and commercializing a conforming product or service. So with respect to open participation, so we've had these standards, we're talking about these formal standards organizations. They've had a FRAND patent policy. Participants have been willing to participate based on the FRAND policy. But now we're tightly integrating this open source process in there. And with that open source process may come a requirement to license patents on royalty-free terms. If that happens, because all of these OSI licenses will essentially require royalty-free patent licensing, those stakeholders may feel that they can no longer participate in the process because it conflicts with their business model. So now we've taken a process where everyone was participating and maybe now some are not going to participate. And finally, I want to talk about conflict with the consistent implementations. As I mentioned, all of these OSI approved licenses have a requirement that you can't restrict the field of endeavor. So you can't limit licenses to those that are conforming to the standard or any of those other things that might be in the SDO's best interest in promoting a successful standard. So we have seen some SDOs deal with the patent conflicts by taking an OSI approved license and doing it sort of, particularly ones that don't have an express royalty-free patent license, ones that are silent on it, like the BSD, for example. And then instead just referring to the SDO's patent policy, say, here's our copyright license, and now for patents, you'll just play by the SDO's IPR policy, patent policy. Others have actually been really clear that patents are going to be licensed, for example, royalty-free for research and testing, but if the use of the open source software is for commercial purposes, the patents will be licensed on FRAND terms. So that, again, that takes care of the patent conflicts, but it doesn't take care of this forking issue because those licenses are still at their heart an OSI approved license. Plus, OSI doesn't really like when you do that. They have been known to complain if somebody's taken a BSD license and slapped on a patent clause that's not royalty free. So then you have tension with OSI as well. So finally, other SDOs, a very small minority at this point, have figured out that they can do a copyright-only license and have it tailored to the SDO's interests. So for example, you get a copyright-only license to the software, patents are governed by the patent policy, and modifications can be made for unlimited for testing and research. And if you're going to use the software commercially, those modifications should still result in a conforming implementation and not a non-conforming one. So let's advance. Thank you. So it all comes down to what's the definition of open source? And even Dilbert thinks that we need to have a clear definition. And I think what we think is that we need to have we need to allow SDOs to have more freedom to adopt a broader definition of open source than the OSD. So if you move on. Thank you. And we have a perfectly good definition. The European Open Source Strategy Plan that I mentioned earlier, which was released just a few months ago, has a great definition. And the definition here, as you can see it, you relies strictly on copyright. It doesn't say that you have to have royalty-free patent licenses. It doesn't say that you can have those, but it doesn't require them. And it doesn't require adherence to the OSD. And so we think that this is a perfectly consistent definition with what we need to do within SDOs when we're integrating open source projects into the SDO's development project. You'll advance. Yeah, thank you. And so now I want to just briefly talk about governance processes. We just finished talking about sort of the differences in IP policies and licensing practices. And now I want to talk about the governance processes, which also implicate some licensing issues as well. And again, we're talking about formal SDOs and some of these formal open source community practices. And we do recognize that all of them are different. You're going to find differences from each and every one. So we are generalizing here, but we're generalizing just to highlight some of these differences. So on the SDO side, one of the telltale signs of this process is that there's usually at least one balloting process, if not more. And as part of that balloting process, there's this notion that anybody who's interested can provide feedback, and they should expect to see that their comments or concerns are addressed in some way by the standards committee in developing the standard and the governing body before they adopt it. So you go through this process, there's this notion of consensus, there's a notion of due process, and the notion that all stakeholders have a say. Ultimately, the standard, as it goes through that process and it advances to the next stage, will take into account all of these different viewpoints and eventually be adopted by the governing body. On the open source side, most projects use like a meritocracy type, and again, I'm talking about sort of these sophisticated communities. The common model here is a meritocracy. And what they do is they start out the project usually assigning an individual with a role as like a project lead or a maintainer. Sometimes they have both, sometimes it's the same individual, but that person or people are responsible for making sure that the project succeeds and managing it overall. There may also be one or more committers assigned at the outset of the project. And the committers are those individuals who are expected to make substantial contributions and continuous ones. And then usually these processes are open to anybody to contribute. But the idea is anybody who's going to contribute has to sign a contribution and license agreement. And that contribution and license agreement is actually going to include in it a grant of a royalty-free patent license. And so anybody who's contributing is also granting royalty-free patent licenses. Now, if you make substantial contributions, continuous contributions, you could get elevated from a contributor to a committer. And the reason that's important is because the committers and the maintainer are the only ones who are permitted to, in general, approve of proposals that are made, reject proposals and modify them. They're the only ones who have right to change the code base. So they have a really important decision-making role. So the more you contribute, the more control you have, and the more the more you can influence the open source in the project. And so if we come back to this notion that if you aren't willing to make those royalty-free patent grants, you're not going to sign that CLA. You're not going to make contributions. You're not going to have a decision-making role in this process. And more importantly, in SDOs that are now integrating open source into their development processes, many of them are not even permitting anybody to provide feedback to the open source code base, even where it may be a requirement, without signing one of these CLAs. So with that, I'm going to turn it over to Justus again, and he's going to sort of synthesize our analysis and highlight some of the specific concerns that we've identified.
Yes, I will try to be brief to leave some time for questions. So I think the premise for our analysis is this general understanding that there is a variety of firms participating in standards development that have diverging interests in the definition of the process and the policies under which the standards are developed. And as a general matter, a lot of firms participating have some kind of intellectual property rights attached to the standard. And a lot of firms participating have some kind of products or interest in participation in product markets in which the standard is being implemented. And typically, a useful way of thinking about a firm's interests in the definition of the standards organization's policies and processes is to think about the relative exposure that the firm has to its IPR interests attached to the standard, as opposed to its interests in potentially proprietary products and services that implement the standard. And so many companies are somewhere in the middle of that spectrum, but some companies tend to focus more heavily on the interest in licensing IPR to other companies, whereas other companies tend to derive most of their profits from selling standard compliant products and services. And accordingly, they need licenses from other companies for doing this. Next slide, please. And one thing that is important to understand, as Michele has explained, there are these very important differences between how many open source software projects function and how many formal SDOs function. One thing is to understand how the quality and the features of the standard development process itself is affected by the fact that there is a reference implementation that is being developed under an open source software process. And one of the main features is this idea that the main reason for which we have the process of developing a reference implementation by the SDO is because standards are drafted with ambiguities. So standards have the goal of ensuring consistent implementation by different products, but the mere document, the technical requirements in the document sometimes fail to achieve that goal and are therefore supplemented with among other strategies, a reference implementation that is intended to ensure consistent implementation across products. So when these two things are developed in parallel, there is potential that the standards developers leave a larger amount of residual choices to the implementation because there is this reference implementation that is being developed in parallel to ensure that ambiguity in implementation is reduced. And in addition to leaving technical choices outright to the process of developing the reference implementation, there is a clear potential that the technical choices made in the development of the reference implementation then feed back into the development of the technical specification. So even though these choices are still taken within the process of standards development, they are actually based on a decision that has previously been made in a parallel process for the development of the reference implementation. And finally, even if the development of the standard itself is not affected and the standard is developed just as it would have been without the development of the reference implementation in parallel, there is still the potential that being the first implementation that arrives to the market, the OSS reference implementation has an influence on other implementations that are subsequently being developed and still determines how the standard is going to be implemented in practice in the market. So because of all these different potential effects, there's a clear potential that this development of a reference implementation, which is formally and quite clearly separated from the development of the standard specification, spills over into the development of the specification and affects how the standard itself is being developed. Next slide, please. And I'm going to be very brief on this, but I mentioned earlier that there is a subset of standards organizations that are subjected to more specific procedural requirements that do not necessarily apply to any and all types of standards organizations or any and all types of organizations that develop compatibility standards. But these definitely include open process, open implementation, balanced IPR policy, and consensus decision making. I think in the interest of time, I'm going to actually skip the details of that because Michele has covered that quite in detail. So next slide, please. And what I want to generally highlight is this general potential for unfortunate consequences that arise when the two processes are under policies and processes that are not fully consistent. The first is that the breadth of participation in the development of the reference implementation is not as wide as it could have been. So there is a subset of the companies and stakeholders that are participating in the development of the standard specification that participate in the development of the reference implementation because the business model that is, or the process that is chosen for the development of the reference implementation is not appealing to another subset of these stakeholders. What that means is that part of the input that goes into the development of the reference implementation is more limited and more partial in scope than the input that goes into the standards development, which potentially makes the reference implementation less relevant and less successful in contributing to the development of the standard. Another consequence is that the reference implementation is successful in influencing the standard, but that because of the fact that the participation in the development of the reference implementation is more limited and more partial, the standard itself is mostly successful in ensuring consistent implementation across the different uses of the reference implementation, and not further beyond to those implementations that are not the reference implementation. So basically, the standard is successful in ensuring wide interoperability only in parts of the market that are potentially relevant for the standard itself. And finally, even if the reference implementation succeeds in informing the standard and influencing the standard, and all companies or the relevant market is still fully compliant with the standard, because in particular because of the significant influence that the SDO itself holds over the industry, so that industry participants feel compelled to participate in the standards development, implement the standard, even though the development of the reference implementation makes it unattractive for them to participate. That might ultimately discourage participation by firms. It might reduce innovation incentives by these firms, and it might ultimately potentially give rise to potentially viable claims of anti-competitive effects by these companies that feel either compelled to participate under terms that are unfavorable to them, or feel deprived of revenues that they could have achieved if the process had been different and consistent with the SDO policy itself. And that is a particular concern if there is a time lag between these two, if firms have first decided to participate in the standards development and then a different process is added onto an ongoing project, and firms that have already made consequent investments related to the standards development now face these additional set of requirements and policies to which they must either abide or being excluded from parts of the final decision making relevant to the standard. Next slide, please. So we have now covered the overview of our own views and analysis. I just wanted to, or we just wanted to put that in context with other views in the literature to see where we stand. Generally, there is relatively wide consensus that some open source licenses, in particular those with restrictive licensing conditions that Michele has mentioned, might create conflict with SDO's FRAND policies. But beyond these particularly restrictive clauses, there are different views in the literature on the more general compatibility between FRAND-based SDOs and open source software, where many authors are actually quite optimistic about this general compatibility and see no particular conflict or potential for conflict between these two systems. And we are closer to authors that from both sides of the issue see potential incompatibility between these models, in particular between the model of open source software that is based on royalty-free patent licensing and the business interests of companies participating in SDOs that rely on FRAND licensing of the essential IPR. And with that, next slide, then. I would like to emphasize our proposed solution that Michele has already alluded to. These conflicts or challenges are not unavoidable. It is possible to develop the technical specification and its reference implementation under a consistent IP framework and a consistent process of consensus decision making, provided that the open source software license is tailored to the copyright over the contributions, and that meritocratic or benevolent dictatorship models for open source software are not chosen for the development of the reference implementation. And with that, I'd like to give the floor back to Axel. Thank you very much. We have taken more time than we wanted to, but we are hoping that we still might get some questions and discussion with the audience.
Thank you very much. It was very complete and very interesting. Let me just ask one or two quick questions, because I don't want to be too long. There is one question for Justus. Is there a risk that by failing to integrate OSS using OSI approved licenses, SDOs such as EDSI risk losing standardization projects to other SDOs and or consortia?
Yeah, I'm definitely sympathetic with that concern that SDOs feel that there are stakeholders that are very heavily invested with particular models of licensing, with particular models of open source, and that the only way of getting them to participate in a particular SDO is offering them a particular model of licenses. What I think is really important to recognize is that there is a very large variety of SDOs out there, and there are models for developing standards that are tailored to all kinds of different ideas of how technology should be developed. So it's important to recognize that some SDOs, in particular EDSI, are just their setup is tailored to the development of standards that are supposed to represent the widest possible consensus of broad ranges of parties. So there's nothing wrong with developing standards that are the consensus of a smaller set of experts or a smaller set of interests. But it's important to make the distinction that this is not necessarily the role of a formal SDO to lend its authority to a partial consensus that would exclude relevant players.
Okay, thank you. There is one for Michele. If simply adopting a tailored royalty-free copyright license and using the existing SDO patent policy for software contributions eliminates those conflicts you discussed, why are not SDOs doing that instead of using OSI-approved licenses for their software projects?
Yeah, I think there's actually a few reasons, and the question's not that dissimilar from the one that you just asked, Justus. So I think sometimes SDOs don't realize there are alternatives to OSI-approved licenses. In other cases, their SDOs or some of their stakeholders, particularly product innovators who rely on open source for their business models, may strongly prefer the OSI-approved licenses. And so they may really pursue this because they're a better match with their business models. And finally, I think that I think that these issues are somewhat complex, and so a number of people don't necessarily understand that there just simply are better options, and that they would be relatively easy to implement. At the end of the day, I do come back to, I think the crux of the problem is what definition of open source do we choose? And if SDOs are concerned that if they choose a license that's not OSI approved, that they won't be able to call it open source, they may in fact shy away from using a more appropriate licensing model. So I go back to the definition that we saw in the European Open Source Strategy Plan, which is perfectly consistent with a sort of a broader definition of open source that would work for SDOs. I'd also like to note that the National Institute of Standards and Technology in the US has also used a broader definition, very similar to what we saw with the European Commission's definition, in which they don't mandate royalty-free patent licenses. And while they acknowledge the OSD, they certainly don't require all open source licenses to adhere to its criteria. So I think there's a substantial precedent at high levels for saying a broader definition is appropriate. And now I think it's just a matter of SDOs thinking through these issues, understanding that there are some risk factors to picking an OSI approved license, and realizing that if they select a different license, a copyright license, and institute processes that already match their own, specification development process with consensus, et cetera, that they can avoid many of the problems that we just discussed today.
Okay, thank you very much. I think that for the sake of time, we will stop the Q&A now. We have received more questions through the chat. Mostly people use the chat instead of the Q&A tool. I'm sorry about this. I will sort them out, and we'll see if we can provide some replies directly on the 4IP Council website. So now we are already over time, and as explained earlier, before the presentation. The recording will be made available on the 4IP Council website tomorrow. And later today, you will receive an email inviting you to complete a 1-minute survey. Please do it. And you could also download the presentation directly from the 4IP Council website. Just like saying before moving on, there will be another webinar on open source software and standards development at the end of March, which will be focused on competition law implications. So that will definitely complement today's webinar. So I invite you to register. And last, but maybe the most important, I would like to thank very much Michele and Justus for giving this presentation, for accepting to have the recording. And I'm looking forward to continuing, reading your research paper that has been available for the last 2 weeks on SSRN with an executive summary also available on the 4IP Council website. So thank you very much. And I wish you a good end of the day.
Thank you.
Thank you very much.
Yes.
Have a good evening.
Thank you.